I seek your Lordship's indulgence in mentioning item number 14 of part 2, my Lord. Lordship, as there's some personal difficulties from the side of my senior, Mr. Villarame, if the matter be taken up after vacation. Yes, my Lord, item 14. Yes, my Lord. Taken consent from. I'm obliged, my Lord.
Admission, item 1.
May I please, Your Lordship? My Lord, in the last court date, the Union of India, represented by the Ministry of Road Transport and Highways, were given one last time to take instruction whether they are going to file their affidavit in opposition.
My Lord, even though reminder has been sent along with the court order, but no instruction has been yet received, my Lord. You'll not be filing. Yes, you'll not be filing. Yes, my Lord.
We have filed in the month of May, Your Lordship. Yes, Your Lordship.
Hearings are complete and the stance of the respondents, excluding the Union of India, is that it is the Union of India represented by the Minister of Road Transport and Highways who has to provide the funds. Now, my Lord, this case is concerning second schedule of the 2013 Act. It's with regard to the one-time settlement, subsistence allowance, and for the cost for the shops. Schedule, second schedule. Your Lordship may kindly see at serial number 5. Serial number 5, 7, and 8 of the schedule. Yes, my Lord. 3,000 per month for a period of 1 year from the date of the award. And one-time financial assistance for running the shops would be 25,000 minimum. Your Lordship will see at serial number 7, my Lord. They have opened up a grocery shop, and some have opened up tea stall, and some motor workshop, and for the my rough calculation would be for all the 12 petitioners, it would be 13,32,000. Yes, my Lord. For each of them, if we count from the date of the award, for this subsistence allowance, it's 3,000 into 12 is 36,000. No, I don't make the calculation there, but I have made a calculation here, a rough calculation, my Lord.
May please, Your Lordship, as per the affidavit in opposition filed by NHI DCL at paragraph number 4, my Lord, if I may kindly direct Your Lordship. 2, 3, and 4, my lord. At page number 4, my lord. Small Roman 2, my lord. And towards the bottom and the 7th line, my lord. The entire land. Small Roman 2, page number 4, my lord. Whereas we have stated, my lord, the entire land acquisition in this area being carried out by the ADC cum Kala, my lord, as per the provisions of Section 3A of the National Highways Act 1956. Now, in this particular writ petition, my lord, the petitioners have not included Kala as a party, my lord. It is the Kala who makes all the assessment. Yes, my lord.
Facts of the case that, okay, their landed property, they have been displaced, all that is not disputed. And then you also voted again that, okay, they are entitled to some compensation. Isn't it?
I am not supporting their claim, my lord. The thing is, under the National Highways Act, Kala has been entrusted to make assessments for required payments now. So,
When you say assessment has to be made,
yes, my lord. Every assessment for the land, crops, and everything, my lord.
that the petitioners, they have some rights, but what is the amount that assessment?
Now the Kala will have to justify why has he not calculated the same, my lord. So he'll have to be impleaded, my lord.
My lord, with regard to my other friend question, I have impleaded respondent number 7, Deputy Commissioner. Now, if I'm not mistaken, all the Deputy Commissioners are designated as Kala authorities.
So who's representing the deputy commissioner?
My lord, under the Act, it is competent authority for land acquisition, my lord.
But who is representing that? Then we can clarify whether it is also acting as the law, isn't it? They have filed their counter affidavit. So in your counter,
Your Lordship,
the deputy commissioner, is he also the,
he is, but Your Lordship, but the case does not include the Deputy Commissioner as Kala. So they have relied on the submissions of the Land Revenue Department, Your Lordship. So if a separate submission has to be made by Kala specifically, then they have to be impleaded. Yes, Your Lordship, but however, the submissions are collective.
Respondent number 7, page 5 of my writ petition, my lord.
the deputy commissioner, being the Kala. Ultimately, he's the one who's not.
Yes, my lord, I agree.
But Your Lordship, if there's a specific requirement that has to be answered by the Kala, then they have to be impleaded as parties, Your Lordship, because this affidavit has been submitted collectively for the respondent number 5, 6, and 7.
So, what did the deputy commissioner say concerning this?
Your Lordship, now since it's consolidated, it'll be hard to decipher whether what his submissions are separate or from or similar to the state submissions, Your Lordship.
Your lordship may kindly come to the affidavit submitted by respondent 5, 6, and 7. Page number 5. Para 9.
By respondents number 5.
Yes, my lord. With your lordship permission, I'll read this. That with regard to the statement made in paragraph number 31 of the writ petition, I say that as the land acquisition is directly done by the MORD, Government of India, through its appointed functionary officer, the competent authority for land acquisition, all the examinations, approval, and payment of compensation of rehabilitation and resettlement is to be done by the mode through NHIDCL. Hence, the state respondent is not in a position to settle the claims of the petitioners. Now, if I'm not mistaken, my lord, the state respondent has not raised any points in their affidavit that I have to specifically implead Kala, because I have already impleaded the deputy commissioner as respondent number 7 as their designated authority for Kala.
Your Lordship, under 3A of the National Highway Act 1956, the Kala is appointed by the central government, Your Lordship. So that it is an autonomous body, Your Lordship. So, Your Lordship, either the additional DC or the DC would have been appointed as Kala, and they'll have to be impleaded as parties, Your Lordship.
So now the deputy commissioner is now impleaded already.
But Your Lordship, in the petition it says DC Lunglei, so it has to be specific nomenclature, Your Lordship. It has to be as Kala Lunglei, Your Lordship. Because then if this pair number 9 has to be
So, on behalf of the Kala himself, what is his stand?
Yes, Your Lordship. So I need to have a separate submission on that regard, and also then he has to the office of the Kala appointed under 3A of the 1956 Act will be impleaded in that regard, Your Lordship. Because if a separate submission has to be made, then the party has to be included as Kala, Your Lordship.
That would be too hyper-technical, I believe, my lord. If your lordship may kindly come to the affidavit of the NPCC, page 4. Sub clause 2. Here at 4 lines from the bottom of the paragraph, the entire land acquisition is in this area is being carried out by the ADC Kala, Lunglei notified under the provisions of Section 3A of the National Highway Act. Now they cannot take a stance that the Kala were not appointed, and the specific nomenclature of Kala has to be written in my petition. Let them say in their affidavit, which they have submitted, that the Kala is not appointed for Lunglei Tlapung Road.
Your Lordship, if one goes through the National Highway Act 1956 Section 3A, it actually specifies that the Kala is appointed and it is an autonomous body, Your Lordship. So that is why so it's not necessary that the DC becomes the Kala. Sometimes it is the additional DC also. So Your Lordship, if any further query is required from Kala, that, Your Lordship, I am not aware. So yes, Your
Unfortunately,
Lordship.
they are not disputing that. They are not disputing that in their affidavit.
Kala as the Kala,
Because Your
My
Lordship,
lord,
if the affidavit,
Kala, whether it's the deputy commissioner or the additional deputy commissioner.
The NPCC has says ADC. Now I'm impleading the DC. I'm impleading the DC as the authority. Now in their affidavit, they have not stated anything that the DC is not the Kala.
yes, Your Lordship,
No,
and also Your Lordship,
that would be too hyper technical at this point, my
if
lord.
the affidavit opposition
They
is
should
not
have- They
satisfactory,
should have mentioned in their affidavit.
Your Lordship, if the affidavit is not satisfactory, then they have to be impleaded, Your Lordship.
Because then, supposing there's an order against the Kala, the Kala takes certain
No.
steps. But if he is the deputy commissioner from Kala, Kala, you have to say, file up.
Your lordship is right on saying that, but if we see the affidavit filed by all the respondents, the ball is on the Union of India to provide the funds. Now,
So you are very lucky that India is not saying anything, isn't it?
yeah,
So obviously, both of them, the state and the NHIDCL, they're also not disputing the fact, but supposing we dispose this in your favor by saying that the assessment has to be made, then it is the Kala who has to do it.
correct. Now, I have just raised that point that at para number 4, page number 4 of the affidavit of the NPCC, they have clearly stated that it's the ADC Kamkala who is notified as the authority by the central government. Now they have stated in black and white, in letters. Now in the affidavit of the state respondent, they have not denied that at all. Now to... Yes, my lord.
Your Lordship, on a technicality, when the DC Lungle will see the respondent list, they will say that they are not included as Kala. So there is always a issue of whether they should respond at all as Kala or they should respond as a state government. That is why it is necessary that if a specific...
Yes, my lord.
At the same time, Your Lordship, if the submissions are not found to be satisfactory and the execution of the order requires the function of the Kala, so Your Lordship,
Let them file their additional affidavit. If they are disputing that the DC is not the Kala,
That the Kala is not a party. There doesn't have to be the additional evidence because they have pointed out that as a Kala, he should also be given a chance because the deputy commissioner, when they filed the counter affidavit, has not taken the stand of a Kala, but just affidavit.
Yes, Your Lordship.
Going along with the
State respondents.
state respondents, whatever they submitted. So supposing the Kala, what will the Kala say? Except mega necessity.
Your Lordship, we are not even sure at this point whether in Lungle the DC is automatically the Kala or not. So in that regard, Your Lordship, if there are some queries which have to be answered as Kala, then definitely they have to be impleaded and then their submissions... Yes, Your Lordship.
the query made by my learned friend is answered by the affidavit of the NPCC, my lord, which I have just pointed out.
See, because it is the Kala who will go in and look into the matter, isn't it? Concerning the,
Yes, Your Lordship.
and
And they have been assigned...
they are entitled to certain rights and the trade also. The trade which you have mentioned,
Yes, my lord.
that also, I think it is for the Kala to verify.
We have annexed all the documents which has not been objected by the respondents. Now, your lordship knows that if the averment made in the writ petition has not been objected, it is deemed to be admitted.
Not been objected, but let the Kala also be a party and because he's the one who's going to make the assessment, isn't it?
Your lordship may kindly come to page...
Make the assessment.
Yes, correct, my lord. I agree with your lordship. Your lordship may kindly come to page 91. 91 is the 3G estimate. Your lordship will see at the bottom, my lord,
91 of what?
or of the writ petition, my lord, of my writ petition.
Yes.
Here, your lordship will see the tabulation, and just below the tabulation, here it is written, competent authority for land acquisition and additional DC Lunglei district, Lunglei.
Additionally,
It is not the DC. Yes, Your Lordship. So that is why...
Now, I have implemented the DC. The DC is the overall administrative authority from the DC.
if he is the listen, if additional deputy commissioner, then as the Kala, he has to be there. The DC as a DC, additional deputy commissioner as the Kala. Isn't it? So the Kala will find another, he is not the deputy commissioner, he is the additional.
Yes, correct.
He has
As per the 3G.
different function.
Yeah.
And now it's there, isn't it? There is a decision. So you file an impleadment application. He will implead it then as the Kala, he will reply as the Kala. Because he is the additional deputy commissioner, but functioning independently as Kala.
Okay.
Much obliged, Your Lord.
More state respondents number, respondent as well. Yes, so I think there's no additional, additional, government advocate for respondents number 5 and 7. Since I understand that it's for respondent number 1 and Mr. Chairman and Chair consulted, then a respondent for
2, 3, and 4, madam.
for respondent number 2 to 4. Eleven, councils. For the state respondents, submit that they are not representing the who appear to be the necessary party in the instant writ petition in view of the is that the one
Page 91.
view of the 3 capital G estimated for acquisition of land, which is made by the Kala / additional Deputy Commissioner of the Learned Council and the Learned Council for the District for time filed application meeting after
2 weeks.
after 2 weeks.
All right.
Item 2.
Yeah, please, Your Lordship. As per the order dated 7/8/2025, the respondents are instructed to file their counter affidavit, which have not been filed till date.
Yes, Your Lordship, I have received a duly vetted Paraguay's comment. If I may be given another 2 days' time to file affidavit in opposition.
Yes, Mr. Chairman, Council for the Petitioner, all the state respondents and appearing on behalf of
1 to 3 minutes.
Yes, what about CBC? Have you filed a counter?
Not yet, my lord.
Have you contacted?
Yes, my lord.
The one in councils.
Item 3.
May it please Your Lordship, similar writ petitions such as WPC number 53, 7 of 24, 55 of 23, 120 of 23 are pending before this Honorable Court for admission hearing. This matter pertains to the JICA guidelines, wherein we have challenged the notification of the state government. So if Your Lordship permits, this may also be tagged along with those writ petitions.
Your Lordship, I haven't, this is the second time that the matter is taken. Your Lordship, in this matter, I have received instructions that the state respondents do not have any objection if the matter is referred to mediation. But we were discussing, I don't think it's feasible because it's JICA guidelines that is challenged.
But, was a similar matter settled?
No, Your Lordship,
No,
it's
no.
pending.
It's pending for admission hearing. In other similar matters, pleadings have been completed. So the stand taken by the respondents will be the same.
They will be the same, that's not for you to say.
Uh-huh.
But do you think there will be some possibility of them, if they they can settle one matter, all the other three pending matters can also be settled.
Your Lordship, that would depend upon the decision of the, in my humble opinion, of the union, because it is the agreement that is entered into JICA and union.
Find out the petitioners also, what you want is that we get some compensation as soon as possible, isn't it? So Union of India,
Union of India is the paying authority.
some settlements, you can make an attempt. In the meantime, file a counter.
My lord, I don't think it, my lord, if your lordship permits, it may be tagged together because other similar matters are pending for admission hearing. And in other similar matters, some of them, the pleadings are completed, where in some, it has not been completed. Uh-huh. Yes, it will be tagged together. Yes, ma'am. Yes. Mediation.
For correspondence number 1, 2, and 9. Along with Ms. Zain Sandu, along with Ms. Devi, so appearing on behalf of Ms. Zain Sandu, learned CTC for respondent number 4, and Mr. Sarman Commissioner and Sandu, learned standing counsel for respondent number 5 to 8. The learned counsel for the petitioner submits that similar matters registered as
The WPC number 53. Yes.
Are pending and that these matters can be tagged together. In view of the instant petition is to be listed along with the same WPC's numbers. The learned councils for the respondents, but wait for further time to file the counter evidence. Praise the Lord. Counter evidence to be filed by the respondents. Meanwhile, the learned councils submit that the matter where we refer the matters may be referred to mediation, since there could be a possibility of the person of the parties coming to particular cell.
My lord, I don't think there will be a possibility of mediation because the issue involved is that the state government has cancelled the notification issued under the
So
2013 Act.
in the end,
Yes.
at the end, what you want
And
is the money.
and JICA and the NHIDCL is the implement authority, and in their counter affidavit, a perusal of their affidavit clearly shows that they are not willing to settle.
That is because you are.
My lord, you are just wasting time. That is the problem.
You see, because there are cases where you think it's impossible for ultimately, but you have to also be better subset.
And
Because
yes, my lord, and based on instructions in the other writ petitions, based on instructions, the NHIDCL will be represented by some advocate from outstation, and it is fixed for admission hearing. So if we refer the matter to mediation at this stage, it will.
what about the other cases? Are you representing? When it can be said,
They come from the office.
so they come. Don't be so, if you cannot settle it, so make an attempt. Because it's for your clients, it's for their benefit, okay, whatever it is, if you come to a settlement, it is final. There will be no, a room for going for an appeal, etc., which would happen whatever, okay, on the side. So for your clients, if you can settle, then they will get a relief. If not, most probably, whatever way that the matter is disposed, there are always venues to file an appeal, etc. So let's see. What is the last sentence? There's the possibility of the body status person, review of the law, all these matters. Review of the law, they instead writ petition along with the other prospective writ petitions. Now, are you representing the others?
I am representing the others in some, but in some others, other councils are such as my senior counsel, Mr. Sidaram Zawa, as well as Jordan Domintanga.
Are we listed again?
So it will affect the other cases as well, my lord.
Listed again in the next week? Or maybe immediately after the issuing the papers. Meanwhile, the councils are to get instructions whether they're willing to have the matter reversed. Then all the matters be listed
Yes, yes.
together, and then we will send.
Yes, yes, my lord. That will be
Then we
better.
can final notice. Meanwhile, the land councils for the respondents are to finally contact.
Oblige, my lord.
Item 4.
Your Lordship, in this matter, may I see 3 weeks' time for filing affidavit in opposition? I am yet to receive instructions.
Yes, is your name there in the process?
This matter, violence on-
Your name is there?
Yes.
Okay, what's your name?
Violence on-
Manat Swami. Ms. Manat Swami, Manat Council for the petitioner is present along with Ms. Mary and Leonard, advocate for respondents number 1 and 2, and Ms. Manat Swami, Leonard Council for respondent 3. The Leonard Council for the respondents agreed for further time to contact council agreements. Review of the law is after 3 weeks.
Is it ready?
Item 5.
Yes.
Appearing on behalf of respondent number 1 to 5. May I seek another 3 weeks time for filing counter affidavit?
Have you contacted
Yes,
the
my lord.
respondents? Okay, we'll have to give them some more time. Mr. Sila Ramzawa, learned senior counsel for the petitioner is present along with Ms. Vane Siami, learned government advocate for respondents number 6 to 9, and Ms. Baby so-and-so appearing on behalf of Ms. Iram Sankhi, learned CGC for respondents number 1 to 5. The learned counsels for the respondents have prayed for further time to file their counter affidavits. In view of the above, list after 3 weeks.
Item 6.
Similar prayer,
Lordship,
6.
there is a prayer for interim. Notice was issued in respect of the interim prayer. Lordship,
Submission for stay of the operation, huh?
since they have not responded to the notice,
What do you have to say concerning this? Notice was received? What is the nature of the prayer made for interim order?
the thing is construction of the Aizawl bypass western site that has been undertaken and under the PM Divine scheme. And Your Lordship, in the process of construction means approaching the authorities concerned have approached the landowners. They have made a settlement with them And the landowners who are the petitioners herein, they have surrendered all their lands, as can be seen in the enclosed annexures. And that was on the basis of the agreement and the notification made by the state government. And in spite of that, the respondents have made alteration of the alignment. The first alignment has been abandoned. Now the second alignment has been followed. And in spite of the fact that the landowners who are the petitioners herein have been made to surrender all their lands for the purpose of construction of the lands.
So you've surrendered, if you're not using it, give it back.
If I may, my lord, on behalf of the state respondents, although this agreement was signed, the LSCs of the petitioners are not taken by the government, nor this agreement was registered,
Oh.
my lord.
No,
So
yes.
possession of their lands have not been taken. The LSCs of the landowners are not taken.
If I take lordship to
That is as per instruction received, my lord.
the enclosed annexures at page 60,
Then it's a disputed, this thing, question of
59
fact.
onwards, 59 onwards, lordship.
If one says that LSCs are taken, they have taken possession of our land.
Yes.
The other says we have not taken possession of their land.
That
and
is
it's then
on instruction.
disputed question of facts. Then we'll have to, you'll have to find out.
So
Isn't
here,
it?
may I take the lordship to page 59? Agreement on handing over and taking over of land. They're not acting on the basis of their
You see,
own
because if after some time they decide to change the route,
alignment.
then you cannot insist that it has to go through the first alignment. Anyways, so I don't think at this stage the prayer for interim order can be considered, can be allowed,
Lots
because
of,
they have to continue their work. You can't insist that they should construct the
Once
road
possession-
within our this thing. So whether it's in possession or not, that we'll have to see.
Once possession
But-
of the land have been taken over by the state.
But
the
they have
question
not
of-
said, but they're saying they have not taken possession.
But when they signed the agreement and when we have submitted all that
So
LSCs,
return the
or-
LSCs, return the
No,
LSCs.
return will not rise.
My lord, the
They have to
LSC is not
compensate
with the
us.
government.
They have to
It's with
compensate
them
us.
themselves, man.
So then it's a
They
question of
cannot
facts.
just deal with the petitioners in such a manner.
Have they destroyed their landed property? That have to be seen. Have they
We
made
have
some
been-
construction
we
over
have
your
not been
landed
allowed to-
property?
We have not been allowed to utilize our land for a number of years.
That has to be seen. Now, they are saying that we have not taken over. When was the agreement? Then
There is
what
a
is
page
the, what is
59.
the,
This was in the year 2023, my lord. 21/12/2023.
Page 59, Lordship.
so then then it's a question of facts that has to be seen, isn't it? Though the agreement was signed, it appears that the agreement was signed. But later, the state respondents decided that we will not go
And on
through
the
this
basis of
route.
this agreement,
Huh?
on the basis of the agreement, we had handed over the entire land to the state government. And on that basis, they have made the application for sanction of the said amount, 500 crore. And for that, on the basis of the land which has been sold to.
Okay, let them file their counter affidavits. They will file their
Let
counter
them file the
affidavits.
affidavit, Lordship. In the meantime, let status quo be maintained.
What is going on in the route, the road?
Contractor was appointed, and the fact that the contractor was appointed was on the basis of the all alignment. It was on the basis of all alignment.
Which is the impugned notification, stay of the operation of the impugned notification. What is the
The-
notification?
Due notification is not the
Page? Is it because the interest of the public as large has to be looked into also?
That
This
has
is
to do
page
with
103, Your Lordship.
103. What is the nature of the,
This is the minute of the joint meeting and the decision made by that meeting. At 104,
so next date, you get instructions regarding the stay of this notification. 103 is the
Meeting minutes.
meeting minutes. So where's the notification? Or stay of the, maybe the meeting minutes, maybe we have recorded, we
Stay of
have
the
recorded
decision,
it wrong.
and the 104 is the final decision that has been made. May I read the Lordship? Concluding the discussion, the chairman summarized that the proposed alternate alignment, option 2, which is running inside and at the bottom periphery of MZU area, is to be followed as agreed by MZU for construction of horizontal bypass on western side to bypass Long Riverine Reserve Forest area. PWD will approach private parties for claiming lands inside MZU area and negotiate with them, as was done earlier with other landowners having plot of lands outside MZU area, for making payment of the crops and assets as required, provided the conditions laid down in the approved agreement format for this project regarding conversion of parcels to LSC or any other form of compensatory payments for lands is to be made for the claimants if they are declared as legal title holder by law code or any other competent authority, or as agreement made between private parties and MZU, if any.
So this is the new route, isn't
Yes,
it, the
it's the new
alignment? So they can,
Take a look at page 107.
they can go ahead with the alignment, there's nothing wrong with that. Whether you're going to be compensated or not, that's a different matter, isn't it?
Yes, that is true, but
Oh.
in the meantime, if the matter is not expedited, Lordship,
So you file your counter affidavits. So if they have found that there's a more suitable route somewhere else, they can go ahead with that. In the meantime, whatever compensation you're claiming or your claim, that also can go side by side. I don't think we need to file and pass any interim order at this stage, isn't it? So file your counter first. Then let's see. Heard Mr. Asil Ramzawa, learned senior counsel for the petitioners, assisted by Mr. Stephen Lalbuatsaya, learned counsel, full stop. Also heard Mr. L.H. Yantriva, learned senior counsel for respondents number 6, along with Mr. Samuel L. Chante, learned additional AG for the state respondents number 1 to 5, and Miss Baby so-and-so appearing on behalf of Ms. Zarim Sampui, learned CGC for respondents number 8 and 9. So the learned counsels for the respondents have prayed for further time to file their counter affidavits. This court has also considered the submission made for stay of the minutes of the meeting dated, when was it dated?
1510.
Dated 15/10.
So on 1510, the meeting was held.
24. To stay the decision, okay, in the minutes of the meeting dated so and so, and find that on considering the nature of the prayer made by the petitioners, which is for payment of compensation, adequate compensation, okay, on the possession of the landed properties by the respondents. This court finds that there appear to be no grounds to stay the minutes of the meeting, which is with regards to the construction of the road in a new alignment. Construction of Aizawl bypass road, okay, on the western side in a new alignment. Accordingly, the pray for an interim order is not allowed at this stage. Just after 3 weeks for the councils, for the respondents to file their counter affidavits.
Orders, item 7.
Instead of allowed, granted.
Your Lordship,
Yes,
Monsignor, who is the leading counsel, have some personal difficulty due to,
you're for the petitioner, isn't it?
yes, my lord.
So we'll grant them
If the
petitioner
matter
is the one
taken on Thursday,
this Thursday. Okay.
yes,
Heard Mr.
Elias Ramson,
Ramsona appearing on behalf of Ms. Lalna Isakifana, learned counsel for the petitioner, who has prayed for adjournment of the matter since the learned counsel is not able to appear due to some personal difficulty. In view of the above, as prayed for, list on Thursday's date. The presence of Mr. Caesar Ramsona, learned special PP for the respondents is noted. Any hearing matter today? None.